Good morning to everyone. Myself, Dr.A.Sabeena, Assistant Professor of Corporate Secretaryship, Erode Arts and Science College. So today we are going to see about the topic Futures of a Company. First we can see about the meaning of a company. A company is referred to as an association of people who contribute money or money's worth to a common fund and use it for a purpose. So it is an artificial person that exists as a corporate legal entity which is different from its core members or shareholders and has a common authentication utilized for its signature. Hence, it has a few definite characteristic features which categorize it from the other types of an organization. Coming to the features of a company, corporate body. So a company needs to be registered under the Companies Act 2013. Any other organization incorporated with the registrar and subsequently not registrar cannot be considered as a separate legal entity. A company exists as a separate legal entity which is different from its shareholders and members. Due to this feature, shareholders can enter into a contract with the company and also sue the company and be sued by the company. Next one is limited liability. As the company exists as a separate entity, members of the company are not liable for the debts of the company. Coming to transferability of shares, shareholders of a public limited company can transfer their shares as per the rules laid down in the articles. However, in case of private limited company, there must be some restrictions on the transfer of shares. Common seal. The firm is an artificial entity or a person and therefore cannot sign its name by itself. It creates the necessity of a common seal that can be used for representing the decisions made on behalf of perpetual succession. The company, being an artificial person established by law, perpetuates to exist regardless of the differences in its membership. In simple words, a company is an artificial person. So next we can see about the number of members. As per the Companies Act 2013, the minimum number of members required to start a public limited company is 7, while for a private it is 2. The maximum number of members for a public can be unlimited, while it is restricted to 200 for a private. Next we can see about the classification of companies on the basis of size or number of members in a company. The company can be classified into private company. So a private company is defined as a company having a minimum paid up share capital as may be prescribed and which by its articles restricts the right to transfer its shares. Public company must have minimum of 7 members and of course there is no restriction on the maximum number. A public company having limited liability must add the word limited at the end. One person company. It also provides a new type of business entity in the form of a company in which only one person makes the entire company. On the basis of control, we can divide as holding company. So such type of company directly or indirectly either holds more than half of the equity share capital of another company or controls the composition of the board of directors. So a holding company may control another company in the following way: by holding more than 50% of the issued equity capital, or by holding more than 50% of the voting rights in the company, or by holding the right to appoint the majority of the directors. So coming to subsidiary company, company which operates its business under the control of another company is known as subsidiary company. On the basis of ownership, government company. So here the government company is defined as the company in which equal to or more than 51% paid up share capital is held by the central government or by any state government or governments partly by central and partly by state government. Non-government company. So all other companies except the government companies are known as non-government companies. They do not possess the features of a government company as stated above. So these were the kinds of companies and its future.